On April 30, 2024, the Criminal Chamber of the French Court of Cassation issued an important ruling that deserves the attention of anyone engaged in public information gathering, particularly in the field of OSINT. The case involved a private investigator who was prosecuted for collecting personal data about employees, job candidates, clients, or service providers of a company. Some of the information came from public sources such as websites, social networks, directories, forums, and regional press. The investigator argued that he had merely compiled data available to everyone and that such work could not be considered unfair. The criminal court had sentenced him to 2 years in prison, suspended, and a €20,000 fine. On appeal, the sentence was reduced to 1 year suspended, but the conviction was upheld. The defendant then appealed to the Court of Cassation, raising 3 main arguments. First, he claimed that using publicly available information could not constitute unfair data collection under the criminal code. Second, he argued that the appellate court had failed to specify which data were considered unfairly collected. Finally, he contested the fact that the court had expanded the period of the alleged offenses to years prior to those mentioned in the referral order, without his consent. The Court of Cassation confirmed 2 major points. It ruled that the mere fact that data are publicly accessible does not make their collection fair. When someone aggregates and exploits information from the internet or social media to build a profile, investigate private life, or respond to an employer's request, without informing the individuals concerned, this practice can be deemed unfair. Such conduct deprives individuals of their right to object, as guaranteed by the French DataProtection Act and the GDPR. The court also upheld the appellate court's reasoning on motivation. The lower court had sufficiently described the data collection method. However, it partially overturned the appellate decision on a crucial procedural point. A defendant cannot be tried for acts committed outside the time frame stated in the referral order unless they expressly agree to extend this period. A vague reference, such as, "since a time not barred by limitation," is not sufficient to broaden the temporal scope of the prosecution. This ruling strongly resonates with OSINT practices, the collection and analysis of publicly available information. Many believe that OSINT is exempt from data protection rules because it uses only openly published information. The decision makes clear that this is not the case. The public nature of information does not grant a free pass to use it for profiling someone, checking their criminal record, investigating their health or assets, or feeding corporate databases, if done without their knowledge and without a clear legal basis. OSINT, when it involves personal data, must comply with the principles of fairness, transparency, and purpose limitation defined by the GDPR and the Criminal Code. For OSINT professionals, this means distinguishing between general information monitoring, for example, tracking sources to detect threats, and targeted collection about identifiable individuals. When a mission involves profiling or evaluating someone, you must be able to justify the legitimacy of the collection, inform the individuals when required, and avoid processing sensitive data without proper authorization. The ruling also shows that employers who hire investigators or use OSINT tools to investigate employees or candidates face potential criminal liability if the collection is deemed unfair. Ultimately, this decision sets a clear line. OSINT is not beyond the law. Accessing public information does not grant carte blanche to use it for any purpose. When personal data is involved, fairness and transparency remain strong legal requirements, and failing to respect them can lead to criminal prosecution. As for me, my role is to guide you through the open source world and help tackle these challenges together. I share insights on key issues, draw from my own experience, and break down trends so that you can safely navigate the digital landscape. If you want to go further, subscribe, comment, and share. You'll discover the keys to turning open source into a strategic opportunity rather than a hidden risk. For in-depth methods and action plans, join me on Patreon. All the links are in the description.